Hello, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I wanted to help you understand the ins and outs of funding your living trust. First of all, the term living trust just means a trust that was formed while you were alive. Let's talk first about who controls the assets in your trust. The trustee you name will control the assets in your trust. Most likely, you have named yourself as trustee, so you will still have complete control. One of the key benefits of a revocable living trust is that you can continue to buy and sell assets just as you do now. You can also remove assets from your living trust should you ever decide to do so. These days, many people choose a revocable living trust instead of relying on a will or joint ownership in their estate plan. They like the cost and time savings, plus the added control over the assets that a living trust can provide. For example, when properly prepared, a living trust can avoid the public, costly, and time-consuming court processes at death, a process called probate, and also court processes that arise when there's an incapacity. That's called a conservatorship or a guardianship process. It can let you provide for your spouse without disinheriting your children, which can be very, very important in second marriages. It can save estate taxes. It can protect inheritances for children and grandchildren from the courts and creditors and their spouses in the event they go through a divorce, and perhaps by some irresponsible spending on behalf of the beneficiary. Still, many people make a big mistake that sends their assets right into the court system. They don't fund their trusts. Funding your trust is the process of transferring your assets from you into the name of your trust. To do this, you physically change the titles of your assets from your individual name or joint names if you're married to the name of your trust. You will also change most beneficiary designations to your trust as well. So let's take a moment to talk about why funding your trust is so important. If you've signed your living trust documents, but you haven't changed titles and beneficiary designations, you will not avoid probate, which is the whole reason why you decided to set up a trust to begin with, or one of the most important reasons. Your living trust can only control the assets that you put into it. You may have a phenomenal trust, but until you fund it, meaning transfer your assets to it by changing title on the asset, it doesn't control anything. And if your goal in having a living trust is to avoid probate at death and court intervention at an incapacity, then you must fund it now while you're alive and able to do so. So what happens if you forget to transfer an asset into your trust? Well, along with your trust, your attorney will prepare a pour-over will that acts like a safety net. When you die, the will catches any forgotten assets and sends it into your trust. The asset will probably go through probate first, but then it can be distributed according to the instructions in your trust. So who is responsible for funding your trust? You are ultimately responsible for making sure all of the appropriate assets are transferred to your trust. But you may ask yourself, won't my attorney do this for me, transfer all my assets for me? Well, typically, you will transfer some assets and your attorney will handle some as well. Most attorneys will transfer your real estate and then provide you with instructions and sample letters for other assets such as bank accounts. Ideally, your attorney should review each asset with you, explain the procedure, and help you decide who will be responsible for transferring each asset. Once you understand the process, you may decide to transfer many of your assets yourself with the guidance of your attorney along the way. Oftentimes, if you have a financial planner that you work with, your attorney will work directly with them to help facilitate the transfer of your assets into the name of your trust. So you may be wondering, how difficult is the funding process? Well, it's not difficult, but it will take some time. Because living trusts are now so widely used, you should meet with little or no resistance when transferring your assets. For some assets, a short assignment document will be used. Others will require written instructions from you. Most can be handled by mail or just via telephone. Now, some institutions will want to see proof that your trust exists. To satisfy them, your attorney will prepare what is often called a certificate of trust. This is a shortened version of your trust that verifies your trust existence, explains the powers given to the trustee, identifies the trustees, but it does not reveal any information about your assets, your beneficiaries, and their inheritances. While the process isn't difficult, it's easy to get sidetracked or to procrastinate getting it done. Just make funding your trust a priority and keep going until it's finished. Make a list of your assets, their values and locations, and then start with the most valuable ones and work your way down. Remember why you are doing this and look forward to the peace of mind you'll have when the funding of your trust is complete. So let's talk about which assets you should put into your trust. See, the general idea is that all of your assets should be in your trust. However, as I'm going to explain, there are a few assets you may not want in or that cannot be put into your trust. Also, your attorney may have a valid reason, like avoiding a potential lawsuit, for leaving a certain asset out of your trust. Generally, assets you want in your trust include real estate, bank accounts such as checking, savings, and money market accounts, investment accounts, business interests, and notes payable to you. You will also want to change most beneficiary designations to your trust, so those assets will flow into your trust and be a part of your overall plan. IRAs and retirement plans and other exceptions are addressed in just a couple moments. So a lot of times people wonder whether putting their real estate into their trust causes any inconveniences. In most cases, you'll notice very little difference. You may even find it easy to transfer real estate you own to your living trust and to purchase new real estate in the name of your trust. Refinancing may not be as easy, as some lending institutions require you to conduct the business in your personal name and then transfer the property to your trust. While this can be annoying, it's a minor inconvenience that is very easily satisfied. Because your living trust is revocable, transferring real estate to your trust should not disturb your current mortgage in any way. Even if the mortgage contains a due on sale clause or transfer clause, retitling the property into the name of your trust should not activate the clause anyways. There should be no effect on the property taxes because the transfer does not cause your property to be reappraised. Also, having your home in your trust will have no effect on you being able to use the capital gains exception when you sell it. Also, having your trust as the owner on your homeowner liability and title insurance may make it easier for a successor trustee to conduct business for you. You want to check with your agent and just verify that with them. Now, what about property that you own in another state? Well, if you own property in another state, transferring it to your living trust will prevent conservatorship and or probate in that state. So any court processes having to do with incapacity and the court process dealing with probate when you pass away. Your attorney can contact the title company or an attorney in that state to handle the transfer for you. Now, what if there's contaminated property? Maybe there was an oil leak in the cellar of your home, or there was a gas tank underground. Property that's been contaminated can be placed in your living trust, but the trustee can be personally responsible for any cleanup. If you are your own trustee, it's a moot point because as the owner, you're already responsible for it. But if cleanup is not complete by the time your successor trustee steps in, your successor and ultimately your beneficiaries can also be liable. If you suspect that this may apply to you, tell your attorney before you transfer the property into your trust. A lot of people will ask the question about whether or not their life insurance should be in the name of their trust. Well, that depends on the size of your estate. Federal estate taxes must be paid if the net value of your estate when you die is more than the amount exempt at that time. Now, some states have their own estate or inheritance tax, and it is possible your estate could be exempt from federal tax but still have to pay estate tax. Your taxable estate includes benefits from life insurance policies you can borrow against, assign, or cancel, or for which you can revoke an assignment or name or change a beneficiary. If your estate will not have to pay estate taxes, naming your living trust as owner and beneficiary of the policies will give your trustee maximum control over them and the proceeds. If your estate will be subject to estate taxes, it would be better to set up an irrevocable life insurance trust and have it own the policies for you. This will remove the value of the insurance from your estate, reduce estate taxes, and let you leave more to your loved ones. Now, there are some restrictions on transferring existing policies to an irrevocable life insurance trust. If you die within 3 years of the transfer date, the IRS will consider the transfer invalid, and the insurance will be back in your estate. There may also be a gift tax. These restrictions, however, do not apply to new policies purchased by the trustee of this trust. If you have a sizable estate, your attorney will be able to advise you on this and other ways to reduce estate taxes. Now, another frequently asked question when it comes to funding a trust is whether or not your car should be owned by the trust. Unless the car is valuable and substantially increases your estate, you'll probably not want it in your trust. The reason is, if you're at fault in an auto accident and the injured party sees that your car is owned by a trust, he or she may think, ooh, deep pockets, and be more likely to sue you. All states allow a small amount of assets to transfer outside of probate. The value of your car may be within this limit. Some states let you name a beneficiary, and some cars do not even go through the probate process. Your attorney will know the laws and procedures in your state and will be able to advise you. Now, I mentioned IRAs and other tax-deferred plans earlier, so let's take the time to talk about them now. Do not change ownership of these types of accounts to your living trust. You can name your trust as the beneficiary, but be sure to consider all of your options, which include your spouse, your children, your grandchildren, and other individuals, a trust, a charity, or a combination of all of these above. Whom you can name as beneficiary will determine the amount of tax-deferred growth that can continue on this money after you die. Now, most married couples name their spouse as beneficiary because first, the money will be available to provide for the surviving spouse, and second, the spousal rollover option can provide for many more years of tax-deferred growth. After you die, your spouse can roll over your tax-deferred account into his or her own IRA and name a new beneficiary, preferably someone much younger as your children and your grandchildren would be. A non-spouse beneficiary can also inherit a tax-deferred plan and roll it into an IRA to continue the tax-deferred growth, but only the spouse can name additional beneficiaries. Of course, anytime you name an individual as a beneficiary, you lose control. After you die, the beneficiary can do whatever he or she wants with this money, including cashing out the account and destroying your carefully made plans for long-term tax-deferred growth. The money could also be available to creditors, spouses, and ex-spouses, and there is the risk of court interference at an incapacity. Now, naming a trust as beneficiary will give you maximum control because the distributions will be paid not to an individual, but into a trust that contains your written instructions stating who will receive the money and when. After you die, distributions will be based on the life expectancy of the oldest beneficiary of the trust. You can also set up separate trusts for each beneficiary so that each one's life expectancy can be used. The rules for these plans have recently been made simpler, but it is still easy to make a costly mistake because there is often a lot of money at risk. You want to make sure you get some expert advice on this. So you may be wondering if there's any assets that should not be put in the name of your trust. As we just discussed, retirement accounts and tax-deferred plans will not change title into the name of your trust. Other assets that should probably not be transferred to your trust are incentive stock options in Section 1244 stock and professional corporations. If you're unsure whether or not to transfer an asset to your trust, just check with your estate planning attorney. Now you may be wondering whether your personal property has to be put into the name of your trust. Well, personal property such as artwork and clothing and jewelry and cameras, tools in the garage, sporting equipment, they typically do not have a formal title. Your attorney will just simply prepare an assignment to transfer these items into your trust, therefore avoiding probate. So what happens if you buy a new asset after you've initially funded your trust? Well, first, find out if you can take the title initially as trustee of your trust. If not, transfer the title right away. And if you're not sure how to transfer it, contact your attorney for instructions on how to get it into the name of your trust. Well, I hope after hearing all of this, you have a better understanding of how to go about funding your living trust. If you have any further questions, you can either reach out to us here at Kelly Longtin Law, or you can contact your local estate planning attorney who has helped you set up your trust initially.